boundaries of Poland were redrawn at the end of the Second World War to, so the sort of, I don't know what colour that is, that colour there was ceded by Poland, and 20 or 30,000 other decisions, admissibility decisions and strikeouts and so on, and a huge weight on the court.
I'm Philip Leach, and I'm Professor of Human Rights Law at Middlesex University, and I'm also Director of a Human Rights Centre at Middlesex, the European Human Rights Advocacy Centre. And we're here today to talk about recent developments at the European Court of Human Rights, and we're going to be talking about lots of issues from systemic human rights violations to jurisdictional questions. So it'll be a fascinating evening. We've got students, we've got NGOs, practitioners. It's going to be a very interesting session, I hope.
There's been a violation of convention and you've got to pay damages, but in these cases they started to order general measures and to say that there was a systemic issue and that this must be resolved, usually by way of changing the law.
Whether there's been a loss of credibility or power within the court, because there's obviously been a vast expansion in the number of findings of serious violations in relation to countries, and they are repeatedly being ignored. And originally they were ignored only by Turkey in the Cyprus-Turkey dispute. Now we have Britain ignoring judgments because it was as I understood it, the Greens case was in 2010, and they said bring forward proposals in 6 months, and the Committee of Ministers...
Are we past that?
The state doesn't need to be in control of the territory on which the person is shot, it's the action now.
Hello, I'm Jessica Simor. I'm a QC at Matrix Chambers. I specialise in public law, EU law and human rights. And today I'm going to talk about recent case law in relation to jurisdiction, in particular extraterritorial jurisdiction, and also issues relating to the interaction of international humanitarian law and human rights law, and the power of the state to derogate from the Convention under Article 15.
The case I want to point out to you as a very important recent development is the case of Jaloud and the Netherlands, in which the court gave judgments on the 20th of November 2014. This case concerned a fatal shooting at a car that went through a UN SFIR, that's the stabilization force in Iraq.
How does the court select which state against which to start a pilot judgment, and how does it select the specific case?
That's very difficult to answer. My colleagues and I tried to answer a few years ago. We did a piece of work that we wrote up. I can give you the reference if you're interested. We went to talk to people in the court, we went to talk to government agents.
If a state has implemented the pilot judgment and has gone back to the court and has been satisfied, like the Polish case you mentioned, does that then put a burden on future applicants to try and distinguish themselves from that pilot case?
Change the law, the practice in the domestic system, and they want the 200 other people then to use the new system. So that's why they will adjourn, quite often, not always, they will adjourn the other 200 and they will wait to see whether the new law is implemented and whether it's effective.